Now, joining me on the broadcast on this big debate is Arnav A. Bagalwadi, who's an advocate and petitioner for the people who were talking about how hijab should be allowed inside the campuses. Brinda Adige, who's a social activist, also joins me. Also, Rahul Easwar, author and activist, joining me on the broadcast, and also joining me, senior advocate Faizan Mustafa. And also with me is Maulana Qasmi, who's an Islamic scholar. Thank you so much for being a part of this conversation. You know, let me take this across to you, Mr. Mustafa. Whether hijab making that cut, whether it is something that is an essential religious practice, has been much talked about. What is your take on that?
So the question is not whether hijab is an essential religious practice. The question is whether Karnataka High Court should have gone into this question of essential religious practice. Because once the Sabrimala review has been accepted by the court, and the court is seized with this question, whether the court should act as clergy and decide purely religious questions. Now, Justice Dhulia very clearly says in this judgment, quoting even Babri Masjid judgment, that the court should not take up theological questions. We are a constitution court and our judges are trained in the common law tradition. And therefore, I personally feel, and Justice Dhulia is right when he says that the petitioners are also responsible for the mess in which they are. Ideally, they should not have made any argument based on Islam that hijab is an essential religious practice. They should have simply argued that it is their choice, it is part of their privacy, it is part of their freedom of speech and expression. And since they were before a constitutional court looking at the constitutional provisions would have decided whether they uphold these rights or whether they go with the Karnataka High Court judgment, very controversial, with which Justice Dhulia entirely disagrees, that the moment somebody walks into a school, then he loses his fundamental rights. Comparing classrooms with the military camps, I think, or the jails was unwarranted. And that way, I feel that Justice Dhulia's judgment on this is a sound pronouncement. So the question is not, whether hijab is an essential or non-essential. It is a question of choice. Okay. If in Iran, their clergy and government would impose hijab, we would oppose it because the girls in Iran have to make a choice. If in India, somebody imposes hijab on them, the girls would be free to argue that we are not going to concede this, whatever we feel like. So ultimately...
Okay. All right. Mr. Mustafa, let me take this across to Arnav. Yeah, all right. Let me take this across to Arnav, and I'll come to you, Rahul. I know you're raising your hand. Just respond to this, Arnav. Do you think that the argument that was put before the Karnataka High Court claiming hijab to be an ERP, an essential religious practice, was something that actually started this entire, case against the people who are choosing to back hijab in the wrong way?
No, see, that was one of the prayers that were made in one of the petitions. And of course, to say that it is an essential religious practice was probably long or short. And because at the same time, had we, had enough material to place on record, yes, this is an essential religious practice, a lot of other things would have followed because, for example, if you were to take the turban, that has the constitutional sanctity of being an essential religious practice. So once that happens, automatically, you have that, protection with the constitution. So maybe that prayer is still a long shot, but at the same time, it still remains a choice of the students. And by no means, when they enter the campus, do they lose such a fundamental right? And can such a right be, lost? Merely based on an executive order or a notification by the government? That's the real question today.
All right. Rahul Easwar, the same thing happened in the Sabrimala judgment. Your response?
Yeah, as a petitioner in Sabarimala case and also as a protester who spent weeks in jail, see, we always maintain that court should not interfere in any religious or spiritual practice on principle. But here the question is different. here the core question, as you rightly pointed out in the introduction, is whether individual right is higher or whether the institutional right is higher. Second, also a supplementary question is, if the individual right is higher, is it an essential religious practice? Holy Quran rightly points out modesty. Prophet Muhammad sallallahu alaihi wasallam rightly points out modesty. Gandhiji in 1947 points out that Quran points out about modesty, not about any particular dress code. So here the core question is whether any dress code is inscribed in Holy Quran, or can it be interpreted along with Hadith? That's another question. So Supreme Court or any court will have to decide on law whether any particular individual has a right overriding that of institution. For example, we can wear, or anybody can wear hijab at any point of time. But when you go to an institution, can you wear it is the question. And one last line. Justice Fatima Bibi, the first female judge of Supreme Court, may it be from any community, Hindu, Christian or Muslim, whenever she used to come to court, she always used to adhere to the court's dress code. And whenever she used to go outside, she used to cover her head and go in the holy Islamic way. So can there be any balance like this that can also be sought? But at the end of the day, education of Muslim girls is important. Hindu-Muslim unity or communal harmony is important. Right now, as an Indian, I welcome this verdict because it points out that two opinions can exist. Even two learned judges have two different opinions. So both opinions are respectable. We should, without hatred to anyone, engage with these opinions and also look at the legality of it.
Okay. It is still a matter of choice. That is essentially what is being underlined over here. Maulana Qasmi, yes, you wanted to make a point. Please go ahead, sir.
Yes. As Dr. Faizan Mustafa earlier also mentioned, this is not the question of religious practice. This is the question of constitutionally provided right of autonomy to individuals with respect to wearing or eating or professing any religion of any choice. On the one hand, we allowed students of one community to go to school with religious symbols like turban, like bindi, and we also allowed recitation of Gita in government-run schools. On the other hand, we are depriving Muslim girls from their right of choice and hijab. So this is not right. It is not equal. It is not
Qasmi, even then it is essential to first determine what falls under the contours of religion. That's important for the courts to bring in and break any kind of law. So what is the point that you are making? You are saying it is a part of essential religious practice, or do you differ in your argument here?
No. There are both issues are there. Number one, when we go to school, when Muslim girls go to school, saying that we have our choice, we have our constitutionally provided choice. So do the school deprive them and send them away. Then they ask, why you have allowed the turban, why you have allowed the bindi. They say this is their practice, essential religious practice. So we say the so is in Islam also. In Islam, the hijab is also essential religious practice.
Okay.
So this is the both. This matter starts with right of personal choice and stop on the essential practice, essential religious practice. Yeah,
okay, let me take this back to Mr. Mustafa, then I'll come to you, Brinda. Mr. Mustafa, you have been a scholar when it comes to Islamic studies also, and also constitutional studies. Do you think the argument that Maulana Qasmi is making is the correct one, or it is to do with interpretation and also an individual's choice, because it is a matter of religion which is purely personal?
You see, Justice Dhulia makes an interesting point where he says that the court should not bother about theological questions, because he very clearly says, because on theological questions, you will always have different points of view. And the court, quoting his words, does not have the authority to uphold any one particular point of view. So definitely there is a debate whether hijab is an essential or is not an essential Islamic practice. But ideally, in this case, we should not go in that debate.
Okay, all right. Brinda, matter of choice. Once again, upheld by the court today. At least one aspect did come out like that. Your views?
Yes, what Justice Dolia said is reaffirmation of the right of choice to the woman to wear what she chooses, where she thinks that that is her modesty or that is her dignity and probably her safety too. Why is it that somebody else, and here the state is deciding that this is a religious garb? We do not have to go into that. Like the justice pointed out and the eminent panelist before me pointed out, theology is not required to be argued and discussed by the court and make decisions. What the court has decided is a constitutional right of choice that this woman can make. It is her right. She can make that choice as long as she's not harming anybody. Now, left with this argument of uniform also to a large extent gets defined and redefined differently. How many times have we pulled up anybody saying your turban is an essential religious practice and these religious practice symbols cannot be worn inside my classroom? We have never said that. We've respected them. And like the other panelists pointed out, it's a bindi, a sacred thread, a chain with a cross on it or a medal on it. Fine, those are all your choices where you don't hinder anybody, and it has continued with the uniform. Nobody said anything about it for this many years. Today we are raising an issue and largely men and the theocratic state, the state is becoming theocratic to say you can't wear it because it is a religious symbol, and we are trying to promote equality, we are trying to promote progressiveness. This is regressive. Absolutely agreed. Parda is as regressive as the hijab. And nobody said that our ex-president was regressive simply because she covered her head in the parliament, outside the country, anywhere that she chose. She was comfortable doing it. And we all respect it. That is it. Respect that choice.
You know, very interesting point that Brinda is making, and it slightly will digress the debate. I'll still go ahead and, allow it. Rahul, it's a tragedy that there is just one lady on the panel today. We're talking about a woman's right to choose, and there are so many men talking about and giving us differing opinions. Why do you think this debate really started? Earlier, this point that Brinda was making, never seemed to have been a problem. Why this political play? Why this matter before the court and now before the apex court?
2 points. One, I'm a Hindu activist, but I don't have any dishonesty in conceding the point that there was a power struggle in Karnataka. There were some communal tensions. There were hardliners of both community fighting with each other. So it resulted in many of these things. Is a reality that we should all be mindful of. That's one thing. Absolutely, yes. But second point, yes, Pratibha Patel ji used to cover her head. There were a lot of people used to cover their head. But the question here is different. Nobody is saying that hijab should not be worn. Nobody is saying that any particular dress should not be worn. The only question is inside an institution. A particular institution can definitely allow hijab. A particular institution can definitely allow any kind of dress. It is up to the institution. So the legal and constitutional point here is not the hijab, not the individual right, but whether an institutional right is lower than the individual right. This is the only question. That's the reason why one judge called the Bija Manual case, the famous national anthem case, and so many things come into play. So here the core question is individual right or institutional right. And constitutionally, we can only elect for institutional right because our institution has certain rights, just like the individuals. But I totally agree with the sentiments. Our Muslim brothers, Muslim sisters should come forward. They should study more. They should get educated. But we should also find a balance in this particular thing. That's the reason why, without compromising the institutional right, which is very important because an institution is run by people, a group, and that institution also has some rights. So the only question is they can wear any kind of dress anywhere and everywhere in the world. But in an institution, when a dress code is there, then come the question. One more thing. If that institution decides, let there be hijab, let there be any other dress, then it is also okay. So the institution's right should be protected. Along with that, I hope Supreme Court will come and blend and balance the individual right and also give some kind of space for our
you also quoted the Bijoy Emmanuel judgment that was actually referred to in the Supreme Court, and that essentially was talking about how if students do not choose to sing the national anthem, they're more than okay to do that. They can't be branded anti-national for that. Arnav wants to make a point. Yes, Arnav, please go ahead.
I'm glad my panelists had in fact brought this out. So the Bijoy Emmanuel case talks about consciously held religious faith. And here it talks about two people of the entire school who decided not to sing the national anthem. But what is the important aspect here is that they did not choose to disrupt or show any disrespect to the national anthem. And I don't see where wearing the hijab in the classroom caters to any disruption in the classroom. I'm very happy that Justice Dhulia has opined in the having this opined in the way he has, insofar as bringing the aspect of inclusivity into the constitution. And in fact, with this dissenting opinion, he in fact has reposed faith in those of the minority, by allowing them to see that yes, this constitution that we have, that in fact allows for inclusivity, allows for heterogeneity, is very much present and still breathing.
Mr. Mustafa, I'll come to you. Why this debate now? Why suddenly has, when I started this entire broadcast and how I wanted to actually go ahead with this very, very, sensitive story. When I, in my school days, talk about the uniform, things were very different. How suddenly, in just about so many years, things have changed to the religious aspect and religious demarcations. School uniforms were not meant to cover or accentuate somebody's religious choice, whether it is the pagdi or the hijab or even a tilak to an extent. Why has it got down to this?
Yes.
No, suddenly, religion is all over. In a secular India, one is surprised to see that young girls are more keen to put on hijab. When I was a student, then no Muslim girl in my class was having hijab. So many times what happens when you are pushed to wall, you assert your identity.
Yeah.
And in any case, there is a huge surge of religiosity. And this religiosity, I am sorry to say, Ishwar is a good friend and I respect him a lot, is absolutely devoid of spirituality. And that is something very, very sad. But the whole question which is there in this case, it's not a question of institutions' right, so to say. What the Karnataka High Court has held, that when you are in a school, you do not have a fundamental right, you have a derivative right. So can we now say that the moment I enter the school gate, I lose all my fundamental rights? Now, if we concede that power to any institution, it would be a bad day for a modern liberal democracy which is committed to liberty and choice and privacy. That is important to me. But I am surprised that girls of modern time are making a choice to have a hijab. I have been saying it and writing it. I'm really shocked that so many of them are interested in hijab.
Maulana